time that was originally set for sentencing. I have received and reviewed the recommendation from probation with Ms. Johnson. She has not, we do acknowledge she has not completed the alcohol screening and assessment through Von Schwartz.
We're jumping straight into a sentencing hearing, and right away you can tell this is not going to be routine. The judge has already reviewed probation's recommendation, and the tone signals concern before anyone even finishes their first explanation. This case revolves around missed testing, an incomplete alcohol screening assessment, and prior warnings from the court. And in sentencing phase, that's extremely dangerous territory for a defendant. When a judge gives a prior compliance warning, like the one mentioned from April, that becomes a legal line in the sand. Cross it, and consequences escalate fast. The defense is trying a preservation strategy here. Highlight employment, show effort, bring in family support, and request delay instead of custody. But sentencing courts focus heavily on follow-through, not promises. Watch closely. This judge is about to measure credibility against prior leniency. Question for you. When someone gets a second chance from the court, should the third mistake still get patience or punishment?
She did miss a test on July 1st. I did discuss this with her yesterday on the phone and advised her to go to community corrections as soon as possible to try to test. She informed me, and so did her father, who is here with her today, that she did go to community corrections this morning before court and was there for about 45 minutes, and they said she was unable to test this morning. We are respectfully requesting that the court not remand her at this time and that we adjourn the sentencing out in August to give her the opportunity to complete the alcohol screening and assessment. She is gainfully employed at St. Joe's. She does not want to lose that job. In the alternate, if the court is inclined to remand.
This is a major credibility checkpoint. Probation just confirmed two things at once. Technically no scram violations, which helps, but also a long reporting gap and a misdirected test after a prior court warning. That combination creates judicial tension. Electronic monitoring compliance alone rarely saves a defendant if reporting and testing compliance fails, because testing is considered active accountability, not passive monitoring. Notice how the judge immediately pivots into direct questioning mode. Short questions, repeated why, and reference to the earlier break given in April. That's a classic signal the court feels its prior leniency wasn't respected. Judges remember when they extend grace, and they expect measurable response. Engagement check for viewers. Which matters more here? No alcohol monitor violations, or missing required testing after a warning. In many courtrooms, missed tests are treated almost the same as failed tests.
And her in both speaking with Ms. Johnson and her father. Our request would be to potentially allow that remand to happen a couple weeks in the future so she can take time off work at St. Joe's so she does not lose that job. Other than that, Your Honor, we respectfully request an adjournment of the sentencing.
And Teresa Clare on behalf of probation. Your Honor, I did communicate with community corrections this morning. She did go over and she wasn't scheduled to do a test today, so she did not.
Now we're watching something very important. The judge is moving from confusion to consequences. The defendant's explanation, forgetting to print paperwork, is landing badly because sentencing conditions are viewed as priority obligations, not optional errands. The judge is also doing something educational on the record, clearly explaining what the alcohol assessment is, who conducts it, how to schedule it, and why it matters for sentencing range. That's not just instruction, that's documentation. It protects the court record by proving the defendant fully understood what was required. He even states directly that without the assessment, the only sentencing option may be maximum time. That's a transparency warning shot. When judges spell out consequences this plainly, it often means patience is nearly gone. Viewer question: should procedural confusion reduce penalties, or is it every defendant's duty to clarify requirements immediately?
Yes, she did do her download of her scram. I just confirmed with them that there was no violations on the scram. However, she had not reported to them after June 15th. So there was quite a bit of info that they had to download on that. So I do know that there was no violations on the scram. However, probation also wants to point out to the court that this court did direct her back on April 3rd, I believe, and warned her about any further missed testing. So she was given a warning by this court back in April about.
And here's the turning point. Bond violation sanction imposed. 3 days in county jail. Notice the legal framing. This is not the final sentence on the main case. This is a contempt and compliance enforcement move tied to violation behavior. Judges use short jail sanctions like this as a corrective shock, a reset mechanism meant to force future compliance before maximum sentencing becomes necessary. The emotional weight increases when the father steps forward. Family support is now entering the courtroom dynamic, and the judge directly recruits him into the compliance solution. That tells you the court still prefers rehabilitation over maximum punishment, but only if follow-through actually happens this time. The broader lesson: missed tests plus ignored assessments after a warning almost always trigger custody. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.